Hello, everyone. We're going to start our third panel on post-conviction litigation. My name is Arne Walter. I'm a 3L at Berkeley Law and the co-editor-in-chief for the Berkeley Journal of Criminal Law, which is co-organizing this event with Chesa Bodine and the Criminal Law and Justice Center. I'm excited to welcome you all to the post-conviction panel. I'll introduce our panelists very briefly, but you can all find more information on the QR code on the little flyer in the middle of your table. So first we have Marc Zilversmit, who is an appellate specialist in private practice and who has been litigating post-conviction RJA claims in court, and we'll talk more about those efforts. We have Morgan Zamora, who is the prison advocacy coordinator for the Ella Baker Center for Human Rights, where she supports implementation of the state's resentencing laws, including the California Racial Justice Act. And finally, we have Lisa Romo, who has been working at the Office of the State Public Defender since 1989 and is now with the Indigent Defense Improvement Division, where she primarily works on issues relating to the RJA. So we're going to start with a question for Marc. You have been doing work on the forefront, bringing RJA claims in court on behalf of many of your post-conviction clients. Can you tell us more about some of these cases with RJA claims at the post-conviction level?
I'm sure. I don't know why I'm considered a leader. I just have filed. I'm listening to all these people. Lisa's got this great listserv from OSPD, and there's great people like Evan Kulik and Elizabeth Lashley Haynes and Sujun Kim and Daniel Harris that are really leading the surge on this. And I listen to them and I think about it and how it could apply to a lot of the cases that I already have, and then I get appointed on them, and then I file the motions that they've been telling me that are possibilities. So, but I have 3 cases going, and I've got a bunch of other cases that I'm considering as soon as I get some time to file some additional ones. So I've got the Louvier case going in San Francisco Superior Court, the Sullivan case going in the First District. Yeah. Okay. The Alanese case just started in Santa Clara, and then there's a bunch of others. So if we skip the case law maybe, because everybody else has talked about that, and then go to the Louvier case. You have that one up? So this is just a complete, I'm just repeating everything that Evan Kulik did in the Bryant case in Contra Costa, which was just a remarkable victory based on rap lyrics and discriminatory language. And the remarkable thing in this is, so I was appointed because I was already appointed for him because we've been litigating his innocence for the last 7 years. I think it's even a stronger case for Bryant, and we have this phenomenon where we have a DA now who is opposing every aspect of the Racial Justice Act. And we have these legislatures who are making these reforms, but I happened to run into Scott Wiener, and he asked me about it. And I said, well, the biggest problem with these reforms is Brooke Jenkins, and the DA. Don't we deserve a DA that enforces the Racial Justice Act instead of, tries to enshrine racial bias and protect racial bias in our system? But so I've been fighting her and her minions, and this is just like a poster case. So he wrote some rap lyrics. There's a gang. The gang case he was acquitted of, but they threw in all this gang, prejudicial gang stuff, and the rap lyrics he's writing, and he's doing this rapping, and he's talking about animals, and so and he's using the N-word, because he's black, and that's a cultural thing, but the Asian prosecutor gets up there and starts reading his rap lyrics to the gang expert, says, so when he says he's an N-word doing this, and he's not redacting it, what does that mean in the gang commanding officer said he's an N-word and he's doing this, you know, and they do that a bunch of times, N-word this, N-word that. And then he's like, and what does gorillas down the street mean? Well, they consider themselves gorillas and big animals. What about this, I'm a hungry bear? Well, he's a bear, he's a powerful animal. You know, how about he's a lion, he's another powerful animal. And then the prosecutor gets up in closing and he says, he's a predator. He's a hungry bear, he's a lion, he's a gorilla, he's a beast. He's a gangster rapper. And that's what he's doing in this case. And, you know, that's why he killed. But the murder, I mean, it's unfortunately titled Murder Shit. And his rap group is unfortunately titled the Headshot Committee. But it's just a generic description of murder and chalk outlines and, you know, sheets covering the body, all of stuff that the actual killer didn't observe. And it really has nothing to do with the actual shooting in this case, which was from a car on a street, and none of those details are in there. So it's just full of racial bias, and it's sort of a poster case, and I'm surprised at the amount of pushback I've been getting. But I do have an evidentiary hearing coming up in March, so you know, onward on that one. If we could go to the next slide. So this is a case I got on appointment on appeal, and it's also got this, you know, just toxic mixture of gangs, jury selection problems, rap lyrics, everything, you know, racial bias, all the things that the legislature's reformed, but it was a pre-pandemic case, and it just sat in Superior Court for a couple years while the pandemic was on, and then finally got resentenced. And they didn't raise the Racial Just Act litigation, so I've had to file a supplemental based on Simmons, and the jury selection was just horrendous. I mean, Jane Brown was talking about being careful in your jury questionnaire. So the jury questionnaire said African Americans commit more crimes than other races. It didn't say it like it was a question. I mean, it was a question because it says I agree, I don't agree, I sometimes agree. But every juror started off the case by being told that African Americans commit more crimes, and that's, you know, I mean, in Buck versus Davis, the Supreme Court said that that's, you know, one of the most persistent racial stereotypes that we confront, and it's just, you know, there's plenty of scholarly articles and plenty of case law that says, you know, that's just wrong. So you start out with this bias question, then some jurors say, yes, I agree, and one of them was kicked off because he was very vocal about his, you know, kind of explicit bias based on his experience. And then one juror was, you know, a little less biased, and said, but he said, I crossed the streets to avoid African Americans because of my fear, and I fear they commit more crimes, and it's probably all just socioeconomic. So he was left on the jury. And, you know, maybe in a Batson error, that's, you know, the failure to object might have waived it, but here, you know, we're in the Racial Justice Act and the AB 3070 world, and that cannot stand. I mean, you can't have a juror that thinks black people commit more crime, judging a black person, whether a black person committed crime in this case. So I've raised that, and the, you know, Attorney General is, well, it's a potential bias. I mean, what's potential? He's crossing the street to avoid black people. You know, he would cross the street to avoid my client. So how is that a potential? Then, and then there's one black juror who's like, this is absurd. How can you be saying this? And so the DA struck him with a peremptory. That's the only time anybody in the courtroom said this is wrong, is it because the judge never said it's wrong. The judge never admonished the jury. And so that's, the jury says if you say it's wrong, you get kicked off the jury. It's just mind-boggling. And They left one black person on the jury, which normally would be in the prosecution's favor, but this is a guy, and I'm learning about this, as we all are, but this is a guy who's Caribbean. He's African American, but he's from the Caribbean, and he has an accent, and he talks all about how there's so much racial bias in America, and he gets pulled over all the time. But when they hear my accent, they know I'm not one of them. They know I'm different. So he actually has, what I'm learning is a bias of foreign-born African Americans against native-born African Americans based on national origin. So that's another Racial Justice Act aspect of this appeal. And then there's this whole wicked stew of rap lyrics and, the N-word in rap lyrics, and it's full of guns and violence and misogyny and gangs, and so that's all folded into one appeal that I'm doing. And I just think if it's some, I looked at that African American guy from the Caribbean, and it just struck me, this is wrong, and I didn't know why, and it took me a lot of thinking to really recognize it, and I just think we have to do it. If you think there's something cringeworthy about something at trial, it's probably a Racial Justice Act violation. So that's the way I'm thinking. And then I've got this discovery case going in Santa Clara, Alanese, and that's just a case where the prosecutor said, my client's friends were attacked by two Norteños, and he went and chased them away with a gun. The prosecutor says if he shoots him right there, it's justifiable homicide, but he chased them for 20 seconds out of the park, and he waited for them to turn to attack him again, and so that's first degree. So, and he went down on first degree, and I did the appeal 6 or 8 years ago, and I lost. It's embarrassing, but that's, we lose cases we should win. And now, I'm just thinking, that prosecutor doesn't say that if it's a white person in a park. That prosecutor only says that if it's a Latino person in a park. So I don't know if this is going to get anywhere, or if I can fold it into an AB 600 claim for resentencing or something, but it made me cringe, and so I'm trying it. And there's a couple other ideas I've got out there. I've got a Latino guy where the shooter spoke Spanish. My client doesn't speak Spanish, but prosecutor said, his last name's Hernandez, he must speak Spanish. I've got a guy with Latino and some Native American heritage, and the prosecutor said, well, they're circling the wagons. So, and then I've got just a school fight case in San Francisco in juvenile court, and every time I go over there, I only see black kids. And I looked at the statistics, and it's 85% black and Latino people on probation in San Francisco. So if I don't get this case dismissed, I'm gonna file that. And then I have one case that's it's not even covered by the law. It's just homophobia, where they said if this guy was in a committed heterosexual relationship, we wouldn't be here talking about how he molested these children. And hopefully somebody can expand the RJA to cover, homophobic statements as well. So thank you.
Thank you, Mark. Morgan, I have a question for you now. Your organization, the Ella Baker Center for Human Rights, is developing a curriculum to educate people who are incarcerated on how to advocate for themselves under the RJA with retroactive application. What kind of question do you receive from people who are incarcerated, and what would be the biggest advance for legal services support inside prisons?
Sure. So just to give a little background for anyone who is less familiar with the Ella Baker Center's work, we're an organization based in California, and we work to advance racial and economic justice for people of color and those with low socioeconomic status, knowing that more often than not, those two identities intersect. And these are the communities that are most directly impacted by mass incarceration and over-policing. And in terms of the commonly asked questions. We have a prison mail program where we're currently in communication with over 10,000 currently incarcerated individuals in California state prisons and jails, and that number is growing by the day as we receive more and more letters and news is spreading about the RJA and our other work. And I think that these questions are really indicative also of the need for increased legal support and community resources for those who are currently incarcerated and looking to make a Racial Justice Act claim. So I think I can divide it into kind of 3 big questions that we've been receiving in the mail. The first of which is, do you have the data that I need to make my Racial Justice Act claim, and how do I access that? Because folks inside know that they need more than just a simple statement that, whether or not that's the intention of the law itself, with the way that it's playing out in court, that they need more than just a simple statement that, hey, I've experienced racism and I need to have my case reviewed. They want to make sure that they get past that initial stage and are at least given the opportunity to be appointed counsel, to have access to someone to help work up their claim and help them bring that to fruition to, hopefully actually receive relief under the law. The second question is, can you help me file my habeas petition? Because I don't understand how to do this. And, I think for anyone who's looked at one or has been through law school or is an attorney currently, there's definitely a learning curve in figuring out how to draft a legal document and submit it to a court. And I think Ms. Brown said it best. Those who are currently incarcerated, Black and brown folks who are currently incarcerated, they know what racism feels like, right? And they know what racism is, but they don't necessarily have the language or feel comfortable or educated enough or, feel that they have the resources to properly articulate it. And again, in a way that is going to get them past that initial stage to actually be appointed counsel to, accurately reflect the really horrific discrimination and bias that they've experienced in their legal proceedings. And, they really just want, a lot of times, someone to review that and assist them and give them confirmation that what they've experienced is real and what they've experienced is viable and that they could potentially receive relief for the discrimination that they've faced. The third question that we're receiving relatively often is, can you point me to a private attorney or a law firm that can represent me? Because a lot of the folks that are reaching out to us and that are currently incarcerated have, very justifiable reasons for not trusting the public defenders that they've had in the past, and have, a lot of times their Racial Justice Act claims are based off of the actions and the language that their own defense counsel used in their legal proceedings, whether that happened 30, 40 years ago or whether it happened 5 years ago. And there's a lack of trust that is, very real, that so many of you who are in the room today in your offices have worked consistently and are proving that, that same level of bias is being fought against and doesn't exist today in your offices, but, they still have those very strong feelings of distrust that don't just go away overnight, especially when, their freedom's on the line. And they also are privy to the fact that you all are at capacity as well. Your offices public defense and indigent defense throughout the state doesn't receive enough funding, and the governor is actively trying to take away a lot of that post-conviction funding and not provide more to support resentencing. And I think that it's just, they want to have an alternative option to be sure that their claims are fully litigated and resourced, and that they're given the opportunity to get to the point where they have an RJA hearing and have their case reviewed. And I know that, none of these are easy questions, and none of them can be easily answered today or tomorrow, but just things for us to think about as we're continuing on in all of our work. And additionally, not necessarily a question that we've been receiving, but just through general knowledge, we need to increase accessibility for non-English speakers. That includes Spanish language resources and, interpreters and resources for interpreters, and resources for folks who also don't speak Spanish but speak the variety of other languages. And the incarcerated population in California, there are currently approximately 75,000 people of color in CDCR custody, and a large portion of those are people of Latino and Hispanic descent and potentially Spanish speakers, but there are also people from a variety of places around the world or who were born here in the United States that speak other languages, and we need to make justice more accessible for them as well. And the Appellate, as Arian mentioned, the Appellate Baker Center is working to help answer some of these questions and increase education through community education, and that's two-pronged. That's inside California prisons, and that's outside in the general community to loved ones and advocates and folks that are supporting their people who are currently incarcerated and bringing their Racial Justice Act claims. On all of your tables, you will have this postcard, which our lovely legal interns have put together, and there's a QR code on there, and you're able to access all of our RJA resources, including our RJA webpage and our Racial Justice Act for All guide. One of the greatest ways that we're able to reach people with this information is through our prison mail program and that RJA for All guide, which is available in both English and Spanish, and it provides, I'm sure a lot of you have already seen it or accessed it or sent it to clients or community members in some way, shape, or form, but that provides general information about the Racial Justice Act that can at least give people the knowledge and the language and idea of what the law is and how to make use of it. And we'll be bringing these postcards into California state prisons and jails anytime that we have an opportunity to, as well as passing them out at community events just to spread the word about the law and make sure that everyone who does have a viable claim is educated and at least has access and a way to find the resources that they need to support themselves. We're also doing community trainings. Again, our legal interns are planning we're hoping to do at least monthly for the first half of the year, trainings for family, friends, advocates, anyone who is supporting someone in an RJA claim or wants to learn more about the law to be able to come, learn a little bit, and really ask questions. And instead of being passed, from person to person and dismissed and ignored, giving them an opportunity to actually come and have their concerns heard and to have those voiced and to give us a space to learn what they need, what questions they have, and hopefully answer those and be able to include that in our RJA cover letter, which is sent out with every copy of our guide so that folks on the inside and community members also have access to that additional information that they need that's not so readily available in our resources or in the other resources that are currently available out in the broader world and from our allies and from you all. And we're also planning more trainings inside prisons. I think our ultimate goal is to go into every prison in the state of California and be able to present on the Racial Justice Act and talk face-to-face with folks on the inside. And for anyone who has ever gone into a prison, you know that that is a very unrealistic goal in a lot of ways, given the bureaucracy and how difficult it is to just make contact with folks and increase programming in a lot of ways. But we're hoping this year at least to go into 5 prisons within the state of California, the first of which, and replicate training that we hosted in San Quentin State Prison last October, where we presented on the Racial Justice Act, and we're able to bring the Alameda County DA in to talk about their resentencing unit and their Racial Justice Act work, and also present on general resentencing laws. But this really just provides an opportunity to talk about the law, and again, like, give some of that humanity back to these folks that have been so incredibly deprived of it in their legal proceedings and afterwards. So we're hoping to do more of those as well, and work with our other community members and allies and organizations inside prisons to reach as broad of an audience as possible. And again, with increasing language access, we'll also be hosting soon, and we'll send that information out, a community education virtual training around the Racial Justice Act in Spanish, and we'll be going back into San Quentin to do a Spanish version of the Racial Justice Act training that we had last October, just to make sure that we're reaching as broad of an audience as possible and as many folks as we can that really need this information and to whom it'll be vital to their freedom. And as we're doing that, we're also contracting with and working with our inside fellows and organizers, folks who are currently incarcerated and want to help their peers and make sure that they're part of that process. And that's an extension of our inside-outside fellowship in a lot of ways. And we're also reaching out to jailhouse lawyers, folks who are currently incarcerated in prisons throughout the state that are assisting their peers in drafting their RJA habeas petitions and doing that work to make sure that they have the resources that they need and the knowledge that they need to spread this information out as far as wide as possible. And we're really just serving as a connector for all of the attorneys in the spaces that we're in that are doing such brilliant work and setting precedents and making it possible for the Racial Justice Act to provide relief to potentially thousands of people throughout the state of California, and just making sure that our incarcerated community members and their loved ones have access to all of the information that they need to take advantage of it.
Thank you, Morgan. Lisa, you play a key role in OSPD to help defenders and defender offices develop capacity to litigate RJA claims. How do you see retroactive RJA claims litigation unfolding, and what will be the main challenges in having those claims resolved?
Well, thank you for that question. I think there are many challenges, but I'm going to focus on 3 that relate to money, procedure, and information. So money, there's not enough. We have defenders who are overwhelmed. The calls, the letters, the petitions, the habeas motions are flooding in, and there's not enough staff to process them, to litigate them, to find experts to support them. So we desperately need more resources. Some of you know that last year the legislature appropriated $2 million just for retroactive RJA claims, and while that's exciting, that I should say that's grant funding. While that's exciting, it's a drop in the bucket. I mean, so many people need assistance. At OSPD, we were tasked with awarding those grants, and we were able to give out 7, and the largest grants were $375,000, and if you run a law office, you know that does not go very far. But that we weren't able to fund the other grant applications that we got, all of which were excellent and really demonstrated the need statewide for this work. The grants included requests for attorneys, obviously, but also for paralegals to screen motions and letters coming in from clients. For experts, we've heard all of the speakers talking about the experts that support these claims, and that doesn't come cheap, and it's time-consuming as well. And then also data and database tools. So some offices are trying to create their own databases, some are trying to create their own tools, and so that also is expensive, and they've asked for funding to do that. So those grants went out or were awarded, but again, that it really is just a very small portion of the money that's needed to do this work. In terms of procedure, there are many questions how this is all going to unfold. One of the biggest questions, I think, is about appointment of counsel. So if somebody files a habeas petition, what happens? Well, we don't know, and right now we probably have 58 different responses depending on what county you're in, and maybe more depending on what judge you get in a county. So the biggest question is, when do you get counsel, or do you get counsel? And the statute that governs that is Penal Code Section 1473. And it's written, I wouldn't say ambiguously, but there are, well, we're lawyers and we always have interpretations, right? So there are multiple interpretations of what the statute means. And so in the defense community, we are arguing that what it means is if someone who is incarcerated files a habeas petition checking off boxes that creates a facially sufficient claim, that person is entitled to counsel. But there are other judges and people who are arguing that no, under normal habeas practice, you do not get a lawyer until you make a prima facie showing and get an order to show cause. Now, it's going to be almost impossible for most incarcerated people to actually meet that standard. It's going to be extremely difficult. So we are strenuously trying to convince the Judicial Council, who has been receptive to this idea that there are different ways to look at this statute. And judges, I know Sacramento, we saw a pleading go on the listserv about the case that they're making for counsel right away. So people are making great arguments, and I think it may end up like the SB 1437 situation. That was about felony murder reform. If folks remember, the first couple of years, there was a huge amount of litigation about whether you got counsel, when you got counsel. Ultimately, it was resolved very favorably for our clients, that basically if you check the boxes, you got counsel. And so that's the model that we are urging courts to follow, but it may end up taking a couple of years of litigation to establish that right to counsel. And then another part of the procedural issues or questions is what document do you file? Do you file a habeas motion? Do you file a habeas petition? Do you file a motion in trial court? What court do you file in? So there are all these kinds of questions, and they bring their own sets of issues. So under habeas practice, if you file a habeas petition, you are supposed to bring all of your claims at the same time. So for for Racial Justice Act, people are asking, well, if I have an A2 claim that's based on the record, something somebody said in the courtroom, and I might have a disparities claim based on charging, but I don't know, because how would I get all that data? Do I have to bring those claims at the same time? We don't know the answer to that. I mean, certainly, if you're just applying general rules of habeas practice, the answer is yes. You need to bring them if you knew about them. And so we're going to have to sort through those kinds of questions. But there are bigger non-RJA questions. If you have other types of claims, non-RJA claims, do you need to bring those in the same habeas petition? Or will you be procedurally defaulted if you try to bring them later? So there are a lot of questions that cause a lot of you to lose sleep at night, I know that, and we are going to try to work through them as best we can, but it is definitely going to take time before we get a law that makes all of these questions clearly answerable. I know another thing that I hadn't even considered, but I'm getting calls from trial defenders who say, we're not authorized to file a habeas corpus petition. We can't do that. Our statute says we can't. So what do we do? And I'm like, I didn't know that. So there are a lot of questions we need to sort out. Oh, and also if you don't get counsel, can you appeal that? If you file a habeas petition, traditionally in habeas litigation, you can't appeal a habeas denial. You can only file another habeas in a higher court and ask them to use their discretion to hear your claim, and usually the discretion is used against you, not for you. Whereas maybe if it's a motion, you will have the ability to appeal that. So these are questions as well. And in 1437 litigation, the fact that people had the ability to appeal the denial of counsel, I think, was what really ended up making that good law that hopefully we can take advantage of. So the third area that I see as particularly challenging is information. To make these claims, you need information. So if it's an A2 claim on the record, you probably, almost certainly, will need the transcript. And what happens if your case is 40 years old or 20 years old? How do you get that transcript? Does it exist? Was it even, was it transcribed? If you didn't appeal, then there is no transcript, right? But even if there was a transcript, do you have to pay again for it? Reporters charge by the page, and it can be very expensive to get, you know. And you were entitled, if you appeal, to the transcript free on appeal. But if you come back a second time, you know, you can be charged for that. So how do people get the record? Again, we're looking to SB 1437 for guidance and help because they managed to figure out some kind of workaround with superior courts where most people were able to get the records if they existed without paying additional fees. So we're hoping that we can reach the same resolution in RJA cases. In terms of A1 claims, so these are actors police officers, expert witnesses, DAs, who may have exhibited bias or exhibited bias outside the courtroom. Well, are you going to need police reports to prove that a police officer was involved in your case? Are you going to need discovery? Are you going to need other court documents? And how are you going to get that, especially if your case is very old? And then, of course, the data question, right? How do you get old data? As we heard from our first panel, the further you go back, the lower the quality of the data gets, right? Because there are fewer data elements captured, it was probably on paper, it wasn't digitized. How accurate is that data going to be? So that's another big problem that we see. But I do want to say, despite all of these challenges, there is good news. I have never seen so many different communities come together the way they are with the Racial Justice Act. We have defenders working with amazing community-based organizations. We have Ella Baker. I didn't know Morgan before this, right? And now I do. We have Debug. We have all kinds of great organizations that I'm getting to know to do this work. And then we have nonprofits like ACLU has jumped in and is doing absolutely amazing work to get data that people can use to bring these claims. We are working with academics, both on our A1 and 2 claims about what is racially discriminatory language, and of course, empirical experts, statisticians, and these are people not just in universities, but in all kinds of interesting nonprofit and other firms like Measures for Justice and what is it, Committee for Policing Equity. I'm blanking on the, you know what I mean. Amazing organizations, and we are all coming together and talking about how to tackle the racism we all know is there, right? We've all been seeing it for years. And we're asking questions like Professor Ball asked earlier, which is, you know, what's your theory? I mean, why are you saying that there's no racism? Because we're hearing this from judges, we're hearing this from DAs, and it didn't really occur to me to push back when you know, DAs say that people commit crimes at differential rates. I kind of just said, well, you know, but we're taking that into account, and here are our numbers, instead of saying, prove it, you know, prove that that's true. How do you know that's true? And so we are seeing people work together to answer these questions, And it's an incredible opportunity to really tell the story of racism and bias in the criminal legal system. And I think it's going to have, eventually, it's going to take a long time. This is not short-term work, absolutely. But it is going to have, I hope, a huge impact on the individual, the lives of our individual clients, but also I think, I'm at least hopeful that it's going to have some systemic impact and change some systems and really make a difference. Thank you.